Hello, I'm Diane Birnholz, and trials started recently against Ryan Wesley Routh, who's been charged with attempting to assassinate Donald Trump on a golf course in Florida back in September 2024, which was less than 2 months before the election. So the trial is taking place in federal court because it involves the attempted assassination of a major U.S. presidential candidate, which is a federal crime. So Routh is also being tried for possessing a gun as part of the attempted assassination, assaulting a Secret Service special agent, being a felon in possession of a firearm, and possessing a firearm with an obliterated serial number. And he also faces charges in state court in Florida. So Routh was assigned an attorney with the Federal Public Defender's Office. However, Routh wanted no part of that, and he asked to represent himself at his trial. So what's the law on that? Well, criminal defendants have a constitutional right to an attorney, and if they can't afford one, one will be appointed to them free of charge. The U.S. Supreme Court has ruled that the Sixth Amendment also guarantees a criminal defendant the right to decline counsel and represent themselves. It's actually a reversible error for a judge to deny a defendant's request and force them to have a state-appointed attorney against their will. Now, when a defendant brings a motion to represent themselves, the court will conduct a hearing where the judge will advise the defendant of their right to counsel, and then will ask the defendant a whole series of questions on the record to assure the court and an appellate court that the defendant is both competent to make this decision and that the decision to represent himself is voluntary and intelligent. Now, this isn't to say that the inquiry is whether representing yourself is a smart decision, because it hardly ever is. Representing yourself in a criminal case is generally not a good idea at all. The average person doesn't know criminal procedure. They don't know the rules of evidence. They probably haven't learned how to conduct an effective cross-examination, or how to make proper objections, or how to prepare a good closing argument. And even an experienced trial attorney would be ill-advised to represent themselves in a criminal case, as they're too emotionally involved to be effective. All right, so you may be wondering, okay, if a defendant like Ryan Routh is not going to be as competent at representing himself at trial, can he then argue later on appeal that he was denied the effective assistance of counsel and get his conviction reversed on that basis? So the answer is no. The Supreme Court has also ruled that a defendant who represents himself at his criminal trial cannot later complain that his handling of his own case denied himself the effective assistance of counsel. So any defendant who seeks to represent themselves solely to mess up their trial so badly that they can try later to get their conviction reversed on appeal, or try to seek a new trial on a habeas petition, is going to be out of luck. So the court system is not going to tolerate a defendant representing himself so that he can muck up his trial so badly that he's then entitled to a new trial. Stay tuned. I have more comments on this case. Thank you very much.